I believe if we informally in Supreme Court agree to a norm rather than an individual basis, it'll help. Reason is we are not one single court like the US Supreme Court, which operates in a unison in terms of sitting. So every bench is a Supreme Court.
Right.
So you have on a Monday, Friday, 13, 14 benches, and there are bound to be a difference of perception how legal work is to be carried out.
Right.
It's the final court. Some discussion maybe in that scenario would help. So I personally followed a practice, and the lawyers knew that this was a practice. So if in a civil case there was three concurrent findings, I said I don't touch it. If there is a first appellate court and the second appellate court concurrent finding, I will not touch it. Yes, if two courts concurrent finding is reversed in second appeal, I will certainly look at it very closely. Similarly, tenancy matters. If a routine tenancy matter comes and two forums are concurrently doing so, why should we touch it? The exception to all this was bail, to my mind.
Right.
I initially, when he came here, also thought there was discussion that are we making this into a bail court, which should not. But it's an issue of freedom of people.
Absolutely.
And somewhere the bail jurisprudence had taken a different turn from that bail would be the rule.
Right.
So if you see across the Supreme Court and across the benches, I would say, almost 1/3 bail matters, I think, have called for interference, including anticipatory bails.
Right.
Which is a reflection of some sort of a problem where the highest court is required to interfere in bail.